So Pat directs the Montana Water Program for Trout Unlimited. He is an attorney focused on water law, a fisheries biologist retired from Montana FWP, and recently serves as a Fish and Wildlife Commissioner for Southwest Montana. And we will get that loaded in just a second.
Thanks, Steve. If I speak at this level, is that audible back there in the back? Great. So it's fun to be back with the Wetlands Council. It's my involvement in it has waxed and waned over the years, but the last time we worked with the Wetlands Council, Linda and Steve, was to create the statewide in lieu fee program to fill in those gaps that were alluded to many times over the course of the earlier program. And that now is called Montana Freshwater Partners. So I think that was, it's one of my proud partnerships with DEQ and the Wetlands Council. This time around, it's focusing on water rights, which is a great topic for the post-lunch crash. I caffeined up quite a bit at lunch, so I think I might have to carry the energy. So if I topple a little over, you'll understand why. So at Trout Unlimited, our Trout Unlimited, our national staff program, we also have council program with which chapters that do similar work, but by and large, we have a three-pronged approach to aquatic restoration. One is actually just doing stream restoration on the ground, including fish passage. We do in-stream flow restoration, which involves more of the water law component. And then out of these projects are policy questions that are raised. And we might resolve those in the legislature or with the council, or sometimes even in the courts. So this one is a great example of how our programs work together with other regulators and other practitioners. And the fundamental question is, when we're doing a stream restoration project, when do we bump up against water rights issues? When do we bump up against the law? Essentially what we're trying to do in restoration, aquatic restoration, whether it's wetland or stream restoration, is we're trying to replace the lost function in the natural water cycle, right? Water in the air falls on the ground, it runs through the ground to a surface water out to the ocean and back and forth. Essentially, if you think about that as the goal, a functional natural water cycle, that'll help us with the discussion as we move forward into the arcane topic of water law. Now you think about water law, it was built not really, it was built more in spite of the natural water cycle, the way water actually works on the ground. It's really essentially an allocation system for whatever's there. And in the arid West, it's the prior appropriation doctrine, right? First in time, first in right. And there's all kinds of little syllogisms and idioms and cliches that go along with Western water law. But if effectively they were created in a mining camp, you know, in Bannock in 1863 was a foundational water law. And it didn't really think about when the water was going to come or how it was going to come. It was just there was only so much there, and whoever got their first crack at it. But they had to put it to a beneficial use, which is a term that you've heard repeatedly this morning. But that beneficial use, if you didn't actually use your water, right, you could lose it. Essentially, we transitioned out of that early mining camp water law to largely an agricultural based water law. About 80% of the water rights across Montana are still held in agriculture. But we have emerging issues with municipalities, municipal growth. We have an ongoing statewide adjudication. We have a lot of issues going on, but few are actually built to accommodate the changes in the water cycle that we're seeing, especially with climate change. We're seeing the changes in pattern, frequency, and style of our precipitation. That's going to alter the water cycle drastically in a way that water law isn't really equipped to adapt to. The science of groundwater hydrology, geohydrology is vastly different than when I started my career back in the late 80s. A lot has changed there, and yet our water law really didn't even acknowledge in Montana that groundwater and surface water were connected until 2002 in a court case that Trout Unlimited was engaged in. So we're at this cusp now with restoration, especially low cost, nature-based or process-based restoration, that is actually a very effective way of restoring the water cycle. but it's starting to raise concerns on the part of water users across the state of, are you stealing my water? And remember, the mantra of water law is whiskey's for drinking and water's for fighting. If you're gonna go put a shovel in a creek to do restoration work, you're probably gonna get somebody to show up with a hostile position, because that's the way we do water law in Montana. And it's kind of corollary to that is, it's better to be upstream with a shovel than downstream with a senior water right. Because we have this rigid law and we have this natural water cycle and the science around it. And then we have the way things really work on the ground. You take as much as you can until someone tells you to stop. And so in this great mix of science and politics and law, it's kind of confounding. So to try and answer this question, when do you need a water right for stream restoration, isn't as easy as you think. So I go to find literature to try and learn more to frame this. In this case, I went to A.A. Milne's Winnie the Pooh. And I don't know if how many of you read it to your kids, or maybe had it read to you, hopefully. But there's a game they invented called Pooh Sticks, where they go to a bridge over a stream, everybody grabs a stick and they scurry to the upstream side of the bridge, and you toss your stick down, and then you run to the downstream side of the bridge, and whoever stick gets there first wins. So Pooh Sticks is what you might consider just a basic use of the water cycle. It's not an appropriation, it's not separating a chunk of water out, it's just kind of enjoying water in its natural state. Now suppose wise old Al came along and he had this brilliant idea. We can have this March Madness thing for Pooh Sticks. We'll take a big chunk of the 3-acre wood and we'll build a big circular river. We'll take water out of the river, and then we'll build a bunch of bridges, and we'll have this great bracket, and we'll make a bunch of money running Pooh Sticks tournaments. Well, that clearly is outside the water cycle. It's an appropriation. So that gray area, as told by Winnie the Pooh, is kind of where we're going to operate and with the rest of this discussion. So the fundamental questions that we kind of have to address is, what is the difference between a use, and I'll call it general use, and what's an appropriation? Essentially, there's a beneficial use component to that we'll discuss. Diversions or impoundments are a big key phrase in water law that sets off the appropriation side of things. But we're building impoundments. If we're just building constructed riffles in a stream that's degraded, is that an impoundment? So we have to think about the language that goes into water law differently than maybe the language of restoration. A core principle in this analysis is the DNRC's guidance, and I'll talk a little bit about that. But it provides a really strong framework to build upon. Also, when you're talking about water law, first in time, first in right. Water law is a property right, or water right is a property right. It's constitutionally protected. So we can't just willy-nilly ignore the water rights. And the language that we use when we talk about, are we impacting other water users or those property rights in water, is, are we causing an adverse effect? So we always want to think about that when we're scoping our project and trying to do this analysis. There's certain kinds of water that have special rules and regulations, and we've actually had them alluded to earlier in the conversation, that bear a little bit of a comment. And finally, always think about, even if a water right isn't necessary for your restoration project, ask yourself, is it advisable? Is it something we might want to do? So that's the ground I want to cover. Now, I meant to start with this, is that part of the grant was to develop a framework. And so I wrote up a report. It's in draft form right now. It can definitely use some review and some comments. So I only have a few copies. Our copier went down right at the wrong time. So I have 5 copies, paper copies here. But if you grab me after the discussion, I'll write down your email and I'll email you copies, invite you to review it. And then hopefully, if you see something that drives you crazy or you'd like changed, or you have something I missed, I'd love to hear that feedback. So let's jump in. The Montana Constitution is interesting in Article 9, Section 3, Sub 3, because it actually articulates the water cycle. In Article or Sub 3, it says all surface, groundwater, flood, and atmospheric waters are within the state are property of the state. Okay, so there's the water cycle in a nutshell. Every drop of water ostensibly is owned by the state of Montana for the use of its people and subject to appropriation for beneficial uses. So this is where I get that distinction between the poo sticks use, a general use. And probably the most prominent one, or the one most litigated, the most general uses are stream access laws. That's all based on your right to use your water as you wish, but it's separate from an appropriation. Water is subject to an appropriation for beneficial use. So that's kind of the first level. Are you interrupting the water cycle? Or are you enhancing the water cycle? Is this a general use? Or is this more of a style of an appropriation? And the way to think about it, I drew two columns and they're basically outlining some elements that would separate an appropriative use from a general use. For example, because water rights are a property right, it's an exclusive right. It's an exclusive right for a person or group of people to use water in a certain manner. It's defined by beneficial use. There's a defined quantity of water that's put to a beneficial use, a specific beneficial purpose, and often in a particular place over a course of a particular period of time, and often with some permanent structure that maintains that appropriation. Now, this doesn't apply to everything, but one thing all water rights have in common is they're legally defensible against other water rights in priority. So when you have a general use of water, as we might with a restoration project, we're going to be mucking around in the water. Some of these things might actually be part of that project. You could consider some of the work you're doing a beneficial use, but it doesn't always amount to a full appropriation. So, and if you're not acquiring an appropriation, all that water could be appropriated or might be appropriated by somebody else. So there's differences, there's common elements, but an appropriation is pretty strict, has all those elements. The courts in Montana did a great job of articulating what beneficial use really means, because we heard about it in the water quality context earlier, right? Beneficial uses are those functions that might be impaired by pollution in the water quality side of things. It's not that different in the water quantity side things, except that beneficial use is occupied by a person or group of people rather than in general. And the other thing is, in water law, beneficial use isn't just a purpose. The court says it's the basis, the measure, and the limit of a water right or an appropriation. So the basis is that beneficial purpose, that not unlike the water quality classification of a beneficial use. But it's more than that. In water law, this is where we get that defined quantity of water. We talk about the basis is the purpose, the measure is the amount of water that's necessary to meet that purpose. So in other words, you can appropriate 400 acre feet of water to irrigate 100 acres of alfalfa, but you can't irrigate 4,000 acre, you can't take 4,000 acre feet of water to irrigate 100 acres. That would be exceed the limit or the wasteful. It'd be waste. So you have a basis, a measure, and a limit. The limit constrains the amount of water. Now contrast that with your stream restoration project. You have about a quarter mile of stream that might be impaired. You want to fix the stream, restore its natural hydrologic function. It's not a specific quantity of water. It is a beneficial use. Fisheries is a beneficial use, but it doesn't have all those components. It's immeasurable. It's without limit. The DNRC guidance was a public process back in 2016, and this really kind of helps outline that difference between a use and appropriation. And it's based on the status of that wetland or stream that is the target of your proposal. Think of it this way: if we're just restoring function of the water cycle, natural hydrologic function of a wetland or stream, we're trying to raise it back to some historical level. In this DNRC guidance, restoration generally doesn't require an appropriation because it's not adding a burden to the source. It's actually restoring the source. In some cases, or many cases, maybe even benefiting the source. So restoration in and of itself does not require an appropriation in general. But imagine the poo sticks arena. I mean, you're creating a new wetland out of whole cloth, sometimes even in a mitigation context. You're creating a new wetlands out of whole cloth, separate from the water cycle. You're actually appropriating water to move it out to a new place. That would generally almost always require an appropriative water right, a water right, a permit, or a groundwater exemption. Now, the gray area, there's always gray areas, especially when you're talking about law, is what if you're taking a degraded wetland and you're enhancing it back to the historic footprint and then some. You're going beyond the historic footprint of the degraded wetland. So you're adding back to restore the water cycle, but then you're adding an additional burden. It might be additional consumptive use or additional evaporation. But it may be that you need an appropriation. Enhancement is also in the, if you read the guidance, it'll be in the appendix of the draft report. It talks about, well, what if you're enhancing it, like improving vegetation, removing invasive vegetation, replacing it with, native vegetation. That would enhance the wetlands or the stream, but it wouldn't necessarily add to the burden. So that wouldn't require. So that's where the gray area is. When you're enhancing beyond the footprint, think of it as it's likely to require a water right. I used John Mulfeld's slides from Odell Creek. This is phase 1, just to illustrate the point, how we might kind of go through this analysis of whether we're creating, enhancing, or restoring. So Odell Creek was channelized or drained through these drain ditch that you see in the photo on your left. And the hopes was to restore the condition, the historic condition, to more look like the right. The drain had obviously lowered the water table. That was the intent of the work back in the 50s. But all that lost function, all that lost floodplain storage had been gone for, almost 50 years. So how might we think about the historic footprint, or whether or not we need a restoration? These are small and I apologize for it, but I'll give you a few landmarks. If you look at the red arrow, that points to the same tree in both frames. One's a black and white photo from about 1950, and one's from after phase 1 in 2008. If you'll notice that transverse black line right in the middle of the black and white, it's hard to tell, but right at the end of that is a dredge. It's actually dredging out the drain ditch. And if you look closely, there's another perpendicular line that goes across. I guess I have a pointer, don't I? Oops. Well, that's escape. So you can see the evidence of the drain in the black and white photo, and in the restored photo, the drains are not visible. If you look to the top of the frame, I'm not gonna use that, but up here, this area and across the top of the wetland in that area is a road. And so focus on that road, and we'll jump to an historic, boy, I really bollocks it up, didn't I? Me and technology. The guy at, or gal at lunch said, that's why I have kids, for the technology. So anyway, if you're thinking about this project, this is a pretty expansive project. I think now we're in phase 19. But in the early phases, the water rights were part of the question. Aren't you impacting downstream water users by storing up all that water? Well, the best place to go is the great. Okay. So just keep your eye on that road that runs across the frame. And we'll switch over to so this is the best evidence for historic extent of a footprint. And again, I know it's small, but I pointed out this road for this reason. The little trees that the red line was you have no prayer of seeing those, but the trees right here and the roads right here. And just by the contrast with these high dry benches, and also the floodplain upstream of the Varney Road, you could tell that clearly this is a wetland. So the phase 1 was clearly within the footprint of the historic wetland. So if we were talking about this in 2025 instead of 2008, we'd say, well, we did the analysis. And clearly, this falls within the historic footprint before it was drained. Sure.
I messed it up that. So we're reporting.
Oh. All right. Well, there's always a delete button, you know. It's just delete. So that's part of I think the essential framework that's already fairly well understood, at least at DNRC and some of the practitioners. But that's really not enough. That's enough to make the upfront assessment of whether or not you're going to create an additional burden on the source. But the next question comes in. Are you ready? So the next question is about how our project might affect downstream water users. And we call that, in Montana, we call it adverse effect. Across the West, it's typically the archaic term was the no injury rule. You can change your water right. You can adjust your practices, but you can't do it in a manner that adversely affects or injures other water users. The fundamental principle in Montana is often called the Spokane Ranch decision or the Crowley Ditch case, where the Supreme Court articulated something that many courts have across the West, is that water users are entitled to the conditions on which that existed when they arrived on the source. So if you take that out of the water rights context and put it in the water cycle context, you think, well, when the earliest appropriators arrived on the source, whether it was the Madison or Odell Creek or another creek, it was largely in a natural state. And the degradation typically happened over the next 50 to 60 years until the mid 1900s, when most of our streams were fully appropriated. So as long as we're edging it back to existing conditions, we're falling within that old Spokane Ranch notion. The term adverse effect it's poorly defined in the law, but really what it boils down to is that your restoration activity can't interfere with a reasonable exercise of downstream water rights. And because water's for fighting, and many of you have experienced this in your work, is that, man, as soon as you move a shovel or a excavator in, someone's going to come in and check on you and see if you're going to hurt their water rights. So the best way to get out ahead of that is just to do a basic calculation up front during your design process of how you might be increasing the burden or actually benefiting downstream water users. And I have just a quick example of that. And this is a stream up in Bridger Canyon, where Trout Unlimited actually holds the in-stream flow water right on this and the adjacent ranches. But I've looked at this, going up to Bridger Bowl. It's just a few miles downstream from Bridger Bowl, and looking at this poor stream that's down cut about 6 feet into its floodplain, largely because of that culvert under Bridger Canyon Road that's up in the upper right corner of the photograph. I outlined the historic floodplain and calculated that it's about a 20-acre area. It's about it's about 4.28 acres total in that polygon. And it's about 300 yards long. And we figured that we could probably fit in about, based on the existing geomorphology of the stream, about 10 BDAs. And each BDA on average would be about 28 feet long. It would extend the stream margin to about 14 feet, and it would add to the residual pool volume or riffled crest about 2 feet. So what's that? BDA. Oh, I'm sorry. A beaver dam analog or post-assisted log structure would be an example. And this is a hypothetical. The landowner hasn't agreed to it. We've just chatted about this, but it's an illustration for your benefit. So if you run the math, the quick math on that, the pool volume is about 784 cubic feet per structure, 10 structures, 7,840 cubic feet. Well, and I've done a bunch of hydrologic measurements. hydrography on our in-stream flow lease. So I know the base flow is about 3 CFS. So this isn't highly precise or anything, but basically it's going to take about 45 minutes at the base flow for, you know, if we built them all in the same instant, it would take about 45 minutes to fill. So that's a first clue. It's just a very basic piece of data that you could use to determine what adverse effects might be. And then depending on the sophistication of the project, you might do a deep dive. You might grab soils off the you know, soil survey, look at KSAT values and calculate out the soil storage and how long it would take. I did a rough calculation. It could be 125 days to kind of fill up the polygon, the soils in the polygon. Could be as much as 528 days. So anyway, it's just a way of starting to add into your design the idea that downstream water rights have to be at least acknowledged. And then if you do a quick look at the water rights query, there's 6 water rights in that greater area, 3 actually on Olson Creek proper that are all being leased for in-stream flow. And so the landowner, we could presume, would be on board. The landowner also owns 2 of the 6 water rights in Bridger Creek immediately below. They're also still on board. What about those other 4 water rights that are within the affected area? Well, if the calculations represent at least some margin of reality, as long as we're not doing this August 15th in the heat of the summer and the peak of irrigation demand, there's probably not going to be much of a way to interfere with the reasonable exercise of their rights. How do you calculate that distance? What's the affected reach? Well, in this case, Bridger Creek has about 16 CFS of water rights in that reach. And within about the same distance, 2 miles distance, there's 5 tributaries, the largest of which, Stone Creek, has a base flow of about 5 CFS. So you add up the base flow of Bridger Creek and just basic hydrology of these other tributaries, and quickly at base flow, you exceed the existing legal demands. It's, yeah, I get it. But I'm just saying that when you're going through the design process, you got to go through the designs for permitting. You might as well take 15 minutes, 45 an hour, just to kind of figure out what kind of situation we have for the water rights. So this might be the most important point of the whole talk, is just for years and years, 34 years I've been at this as a fish biologist and as a water lawyer. People are scared to death of saying water rights or delving into water law. Our whole water quality and water quantity laws are split for this fear of crossing the lines. Don't be fearful. It's not as bad as it seems. And there's ways to actually smooth out. Talk to those 3 landowners downstream before the project. Say, here's what I think is going to happen. And avoid the eventuality where we go from just Pat's guesswork about restoration and water rights to a bunch of court cases that stop all restoration for 5 to 6 years. That's what we don't want to happen. And you can help hedge against that by just giving it a shot up front. The type of soil stuff we use for in-stream flow projects or wetlands projects is all readily available online through the soil survey, water rights, the water rate query, hydrology. USGS has tons of historic gauges all over the state, not just the active ones. DNRC has their stage database now that it's accessible for a lot of smaller streams. Consumptive use calculations, the standards that we use in water rights world to calculate consumptive use. You can look at that rule 1902-16 and you can start to frame out like how many acre feet of water, how much consumptive use might you be increasing by doing this project the way you want to do it. And aerial photographs are gold when it comes to water rights and looking at, you know, that historic footprint. This is kind of an odd subject, but I think for this group is more than anybody, it's kind of a important thing in the muddled world of water law. There's certain classes of water that have special status. And there's 2 kinds with the same name. So in the water quantity world, in water law, you have wastewater. It's 2 words. In the water quality world, you have wastewater, one word. And they don't necessarily mean the same thing, although they have similar implications. So start with wastewater. That's the water that discharges after beneficial use and irrigation that stays on the surface and then goes to a surface source. Wastewater. And its quirk is that it's already associated with a bunch of water rights upstream, right? They had a water right, they diverted it, put it to beneficial use, and this is the waste that's left over. One can appropriate that wastewater, but in this situation, like some of the projects we're trying to do is capture this wastewater that's carrying nutrients and siltation to the river. We want to capture that in a wetland and let the wetland treat it and then pass it on cleaner. Well, we might not need a water right for that if we're staying within the historic footprint. But one thing we can't do is compel the person or the people who initially diverted that water to continue to provide that water. They can clean up their system and eliminate their wastewater. And there's not much you can do about it. So that's one thing to think about in the wastewater context. Now let's talk about wastewater. So wastewater is that which remains after the beneficial use of a municipality, say, where they've got a water right or permit to divert water. They distribute it out to their customers who cook and clean and bathe, and then that water goes into a wastewater treatment facility. Well, there's two permits associated with that, right? Or at least there's the water rights that allowed the initial taking of the water for beneficial use. And then there's also on the other end, so the water quantity end regulates the front end, and the water quality end on the back end would be regulated through an NPDES permit, a discharge permit. So in this quirk of water law, if the city, for example, captures that wastewater and uses a wetlands to further scrub it or clean it, it would not likely to have to get another water right to do so, as long as it was within the scope of that discharge permit. And I think we heard that earlier, and I can't remember the citation, but that's part of the code, part of the exemption to the state's waters, right? So you can use that water in a wetlands. Often you can't in a natural wetlands because of the Clean Water Act issues, but you might use it in a created wetland. So this is one instance of a created wetland where you don't need a water right, as long as it's within the discharge permit. So if all you remember is that wastewater is more than one thing, and it has special restrictions when it comes to using that water for restoration purposes, it's just something to think about. And here's just an example. This is a town nearby, southwestern Montana, where again, you can't see it, but at the very top of the center of the photo is a little drain ditch that goes straight north to the Gallatin River. For many years, those two squares in the middle used to be the old sewage treatment settling ponds. They were taken out of service, and a very state-of-the-art facility was put in to treat the municipal wastewater, and it's discharged into this former stream, now more of a ditch, and it goes out to the Gallatin River. So it's wastewater from a municipal facility, but there's also wastewater from a nearby dairy and irrigation that also gathers in that stream. But just as an illustration, there's two options that we've looked at. And the principle I'm trying to illustrate is if you put it to a new beneficial use outside the permit, you do need a water right. In this case, we wanted to divert this, and I think it was actually at a Wetlands Council tour or training back around 2003 that we toured this property. You remember that, Larry? Where what the idea was to capture that water and move it through reconstructed or restored wetlands on the floodplain of the Gallatin to strip out all the rest of those nutrients. We could do that still with wastewater or wastewater as long as we were within the historic footprint. Another option has arisen that using that wastewater and discharging it into the groundwater, as long as it's within the NPDES permit, to actually do water quantity mitigation with wastewater. So I know several of you are working on that and could articulate it much better than me, but there's other ways. So long as we're not taking that water and putting it to a beneficial use, so long as it's within the city's MPDES permit, there's nuances there to consider when you're doing a restoration associated with these kinds of water. So, you'll see in the draft that I've been struggling, Steve's been helping try and come up with a better analytical framework to use for practitioners in the field, how you might do an assessment. And I'm happy to share that report again. But basically, you want to look at your objective. What is the objective of the project? Are you trying to create a wetland mitigation site in perpetuity? If so, then you need to appropriate a certain amount of water over a certain time. That puts you in the appropriation mode. If you're simply trying to restore that water cycle, that natural function, it's likely that you would not need a water right. When you think about this, it's one of the key factors that the DNRC looks at. Is there a permanent diversion or impoundment structure that requires repeated maintenance? So, well, definitely beaver dam analogs would be an impoundment, even though they're small. Are they permanent? Well, not really. They're kind of built to be over time to age out. And do they require maintenance? Well, depends on the nature of your permit, I suppose. So think about the permanence of your diversion. Are you diverting water from the water cycle? Or are you not? Think about that, the burden on the source. Think about adverse effects. Do a quick calculation. Figure out how much water you're going to manipulate in the short term. And if you really have the inclination, it's worth trying to figure out how much that might produce in the long run. You actually might be benefiting downstream water users, which is one of the principles behind this natural or process-based restoration. Think about whether the source of the water has a special requirement. And then finally, even if you don't have to have a water right, it might behoove you to actually acquire one if you want that project to have water and not be appropriated away in the future. If you're going to invest your hard-earned money or grant money or the state's money into a restoration project, it's worthwhile to think about investing in maybe it could be a changed water right. Say our rancher partner doesn't want to irrigate that pasture anymore. He'd rather have a wetland there. He or she might want to lease us their water right for in-stream flow or donate. You could get a groundwater exemption for some of these where it's a 10 gallon per minute, kind of like an exempt well, except it's an exempt groundwater permit for up to 10 acre feet of water a year. It's another way to protect, to create a legal entitlement for that appropriation. And finally, in some watersheds, there's water legally available to appropriate through new permit. It's a difficult process. So in any case, I'd like you to think about it this way. Is that, you know, part of our restoration efforts are trying to restore something back to a natural state. And our budgets are always tight, right? You always get that $80,000 grant, and then you find out it's a $180,000 project. Well, do you really want to add on another $50,000 court case to defend your restoration project? Or do you want to invest another $25,000 into a change application to get a water right to protect your investment? So it's worthwhile to think about it. Don't shy away from this conversation that has been a tender topic for many years. Hopefully we're reaching a point where a council like this and a group of professionals can actually have conversations and answer those questions. The rest is all something I've said 14 times. So thanks for your attention. This is my email address. Or you can I can write down your email if you want me to send you that report. So thanks for your time. How do we do in spite of my...
Actually, Pat, that was really good. We have time for questions.
Historic there several times, but our climate is not historic at this point. And so how do we move forward under those rights that are set up with historic versus what our current precipitation regime is with snow versus rain and whatnot?
I think that goes back to the fact that water law is frozen in time, and we are not. Our science is not frozen in time. So I think the farthest back you can reach to pre-disturbance is often an aerial photograph now. The old people that used to be on the ground that could fill out an affidavit are now passing along. And I'm not far behind apparently. So I think historic is gonna have to, it's a shifting tide where water law doesn't shift. So as an illustration of what my point trying to get at is most irrigation rights in Montana extend from pretty much April 15th to October 1st, or maybe October 20th. That's the period of diversion. Where nowadays, had a guy call me yesterday from down at Zorky saying, I started irrigating today. You know, it was March 12th. There's not a, well, there might be an irrigation water right out there for March 12th, but that's a reality we're going to face, right? The growing season might actually be starting before these water rights. So there's a lot of issues in that trying to define what historic is in a changing climate. So all I could say is do your best. Try and reach back as far as you can. You can use just geomorphological features on the ground. You can use hydric soils that have been there for, some have been drained for 150 years, and yet you still have hydric soils. So there's lots of ways to build your case. If it gets really sticky, it's really important to do that. But the whole idea about restoring the water cycle is building resiliency, right? In the face of these changing times. So. Yeah, slow it down, store it up. Yeah, one of my colleagues calls it massively distributed storage. Rather than building a 50,000 acre foot reservoir, what if we build 5,000 10 acre foot storage?
Yeah, Pat, based on my experience with water rights over the past 30 years, I would recommend highly for people who are doing restoration projects to get a protective water right, specifically with the amount of development that is going on across the state. I have had instances where my groundwater water rights were affected by development. So it is imperative that if you are doing a restoration project on the ground and you have a water involved, that you protect it in some manner, because you never know if a gravel pit's going to go in next to you or a 500 house residential development.
I think it's important to look at the investment you're going to make in that project. You know, if you're investing a ton of money in hopes of holding that in perpetuity, you can't go wrong. If it's a pretty simple, you know, just trying to rebuild a stream channel and build some habitat, maybe it doesn't rise to that level, but it's always something you should think about. Thanks, Larry.
Actually, I was just gonna, with you two gentlemen in your little back and forth, what we've done on the Blackfeet Reservation is we started piggybacking renewable snow fences using natural materials, willows and everything that's kind of native to those areas, so that we can have a lot more runoff during the springtime, piggybacked with the BDAs. And we found that that's actually helping a lot more with the available water come springtime. So.
Thanks, Emerald.
I have a question. Hannah with the Non-Point Source and Wetlands Program. One of this sounds like it'll be a really helpful framework. One of the decision points in the framework was about, like, is the objective of the restoration project to restore the historic extent of the stream or wetland? And why is the historic extent of groundwater not included in that question?
I think it should be.
My question comes from, you know, there's a lot of talk of groundwater recharge. And I was thinking about this a little bit in the morning when we were talking about exemptions to WOTUS that have kind of always been on the books, being like, if irrigation was to be removed, would that dry up the wetland? yeah, we've moved water around on the landscape over the years. So I think it would be maybe more of a challenge to identify that historic extent of groundwater.
Yeah, in fact, that picture I showed of the Varney area on the Madison floodplain, if you look at a current aerial photo of that, that wetlands reach has now moved upstream about a full mile, that really dark footprint. And that's because of irrigation that was added in the 50s above there. It's filled up the bowl. So that's a great point. I think the most important thing is, in viewing this in the scope of the context of wetlands or stream, is wetlands and streams are surface expressions of groundwater movement, more or less, right? Especially at late season base flows. So I think there are probably many cases where you might be actually relying on return flow. Like the Odell floodplain probably picks up a ton of return flow, or used to, when we flood irrigated everything from Indian Creek all the way north to Cedar Creek. It was extensively flood irrigated and patchwork quilts. And so nowadays we're switching to pivots. So a real common issue that we might run into is that return flow, where 45 to 55% of the water applied to a hayfield now, or used to run into the alluvium and then find its way to stream, is now not finding its way because the pivots are so efficient, 95% efficient. So that change in return flow could muddle that. That's a good point. And something worth flagging in the report when I get it polished up. So thank you.
Okay, thank you. And on a note with that, check out, there was a study done on the Snake River Plain in Idaho, where they did a lot of conversion to pivot irrigation and noticed the late season stream flows dropping because they were not getting that water that was essentially irrigation return flow that had gone subsurface. And they've been paying farmers and ranchers to return to flood irrigation. And it's something I think in the Bitterroot we might see at some point as well, where a lot of groundwater is coming from irrigation. And people have put their wells into it and they rely upon it. So just some really interesting things that happen